Hi everyone, I am Ritika and I am joined by my colleague Soumya Gulati. In today's podcast, we will be discussing an important recent Delhi High Court judgment in the realm of arbitration. Now, this judgment clarifies the nuances of partially setting aside arbitral awards under Indian law. Soumya, would you like to take us through the judgment briefly?
Thank you, Ritika. The case in focus today is NHAI versus Trichy Thanjavur Expressway Ltd. This is indeed a pivotal case that redefines the contours of the court's authority under Section 34 of the Arbitration and Conciliation Act 1996. One of the central themes explored is the principle of severability. The court emphatically states that the claims with an award devoid of interdependence can be treated as distinct awards.
So, which provision of the Arbitration Act does the court rely on to find such a power to partially set aside awards?
So the Delhi High Court basically focuses on Section 34 subsection 2A4 of the Arbitration Act. This section provides the courts with the power to partially set aside awards.
But this section only refers to setting aside of awards on the ground that the arbitrator decided matters which are not submitted to arbitration, right?
Yes, so the court used the principle of severability set out in this section and extended its application to even other grounds for setting aside under Section 34. So an award may be partially set aside even on grounds such as violation of Indian public policy or the non-arbitrable nature of the subject matter of the dispute.
Right. Now I understand that the Delhi High Court differentiated from the Supreme Court's judgment in NHAI versus Hakeem. What was the court's analysis while doing that?
In NHAI versus Hakeem, the Supreme Court had held that the courts cannot modify awards. In the present case, the Delhi High Court differentiated partial set-aside of awards from modification of awards. They held that a partial set-aside does not amount to modification, since the court is not substituting the tribunal's reasoning with its own. The court is merely striking some independent portions of the award in their entirety.
And how does this judgment impact the arbitration landscape in India?
This is definitely a paradigm shift. The court's nuanced approach aligns with the idea that preserving the overall integrity of an award is crucial. The court ensures that a more targeted interventions surgically addressing specific legal issues without jeopardizing the entire award.
Right. It's interesting that the court actually looked at the drafts of the UNCITRAL model law while deciding this. I understand that the court had found that the initial drafts of the UNCITRAL model law had a provision which allowed for set aside of awards in whole or in part, but the final draft of the UNCITRAL model law did not actually have this provision.
Correct. So the court concluded that the omission of such a provision from the final draft of the UNCITRAL model law does not mean that it was deliberated upon and intentionally removed. Since there was nothing to suggest that any such omission was reasoned, the court did not find any basis to decide that the UNCITRAL model law prevented any partial annulment of awards.
Yes, this is also interesting because partial annulment of awards has seen some recognition internationally. For example, even under the Exit Convention, a party can apply for full or partial annulment of an award. Even courts in Canada, France, Sweden, and Austria have partially set aside awards. So this concept is not exactly alien to the arbitration world.
Yes, that's true. Now it remains to be seen how the other Indian courts, especially the Indian Supreme Court, treat this Delhi High Court judgment. That basically concludes our in-depth exploration of NHAI versus Trichy Thanjavur Expressway Ltd today. Thank you all for joining us.